Okay, folks, I want to talk to you today about interim hearings and how to navigate them. Now, I don't know why I haven't produced a vlog about this subject before, because it's actually really important. Quite frankly, very few cases get all the way to trial that are issued, and most of them get settled, and often as a result of an interim hearing, which has brought the parties together in front of a court, exercised people's minds, made them realise how big the legal bill is, and that's where settlement occurs. So actually the interim hearings are really rather more critical than having the advice that I could give you about trial. And the other thing is they are very different from a trial. And one of the biggest misunderstandings that litigants in person have about interim hearings, and which causes people's blood pressure to go up, right up through the roof, is that they think, and if there's anything that you take away from this vlog, and you've got another meeting that you're hurrying to, you're late for an engagement, and you're just logging into yours truly, take this nugget away with you, is that it's not about beating the drum of the strengths of your case as you've laid out perhaps in your particulars of claim or defence, or what happened before issued. It's about closing with the issues that are specific to that particular interim hearing, of which there are many in a piece of litigation, particularly if it's at the high end of a multi-track case. But even in fast track, and even in small, there are often preliminary, interlocutory, interim hearings along the way to trial. Okay, so I'm just going to talk a little bit more generally about this point that I've made. Then I'm going to refer it to actual examples to give you a flavour. And these are cases that we have run, and a lot of them are quite recent, so this is hot off the press. And then I'm going to deal with a few other issues. I've just listed them here. The fact that it's an opportunity, the fact that and specifics on N244 applications. I'm not going to go into it in a major way, but I'm just going to quickly cover that. And then I'm going to run through all the different sorts of applications that, that interim hearings are involved with, because they're often arise out of applications, though not always by one or the other party. And stay tuned till the end, because I'm then going to talk about transcripts. And I've had an epiphany about court transcripts and the importance of obtaining them from courts after an interim hearing, so stay tuned for that. And then I've used some foul language in this in the final heading. FF the law, frankly. Finally, F the law, frankly. And I'm going to just touch on the issue that people some litigants in person get completely tangled up in the law. And the more revolutions the earth goes round the sun in my life, the less value I place upon my legal education, i.e. all the stuff around, the English law, and the more emphasis I place upon taking simple civil procedure rules, the overriding objectives. This is for litigants in person, but it could also apply to lawyers, actually, not getting tangled up in the law and using your common sense and closing with the issues. Okay, so first things first. And I'm going to do a vlog coming up soon, if not this year, early in January, on issues generally, because that's just such a big can of worms for litigants in person. But I'm in terms of closing with the issues today, I'm just going to talk about the importance of understanding what your particular interim application is all about. Now, the problem that a lot of litigants in person experience, and they come away angry, and they come away to us saying the judge is corrupt, and I wasn't given any time, and he didn't hear me out, and all that sort of thing. Actually, the real reason and this is a painful experience for lawyers as well as litigants in person, believe me, is that it's a dogfight, right? Except that you're in a dogfight, an interim hearing. Except that the judge isn't going to care about the strengths and weaknesses of your case, because he's just concerned with preparation, conduct of the proceedings, yeah, making sure there's been proper disclosure of documents, making sure particulars of claim have been properly prepared, okay? He's not interested in you soapboxing and wasting precious time. You might only be listening for 10 minutes because you haven't thought through before the hearing the particular issue that this interim hearing is meant to address. And it's really just a sense of perspective. Now, plug alert here, but this court wingman service that we're providing is all about having a call a friend type situation where you're faced with let's say it's a strikeout application from an opponent, let's say it's a bank, and it's listed for 2 hours and you have no idea what you're doing. Court wingman, and it's not a very high value case such as you're instructing lawyers, court wingman is there to talk you through it. I mean, that's where we add most value, is where, let's say you've sent us as a PDF a strikeout application that you've received from your opponent, and you're preparing your response, and you're like, what do I do? What's going on? What's a strikeout application? We could give you very useful advice. I say could, we can. I'll give you very useful advice in just 1 hour with that application in front of us. Okay, so the very first thing is people get really angry with the court because the court has made an order that their particulars of claim will be struck out, or more commonly they've given a litigant in person sometimes as short a time as 14 days to amend and refile and reserve their particulars of claim. Yeah, that'll often happen at an interim. At a preliminary hearing. It could be only 10 minutes. You know what I mean? Or it could happen after a strikeout application. It could even happen on the papers. So the other side could object to your particulars of claim, or the court could, of its own volition, look at your particulars of claim. A judge looks at the papers to decide what to do with the case when it first hits his desk, when he's got the statements of case together, and he'll say, these particulars of claim haven't correctly pleaded a cause of action, or they're not concise, or whatever. So, in the case of amendment issues like that, you will need to turn up at that next hearing with a fresh set of amended particulars. Yeah, that's the only issue that the court is interested in, is you having amended your particulars. The issue here is your opponent is saying your particulars aren't fit for purpose. Yeah, so before you even get into that strikeout application, you need to have reviewed whether or not your particulars of claim are fit for purpose, and obviously looked at your opponent's strikeout application. Yeah, because if you decide that upon reflection your particulars of claim aren't fit for purpose, you then want to avoid the cost of a strikeout application, which could cost you $2,500 because they'll send a barrister. Because the court will say you've wasted everybody's time for not having got your particulars of claim the first time. So as that interim hearing is approaching, you need to be deciding whether or not, well, no, I do feel my particulars of claim are fit for purpose, and I'm going to fight the other side and try and win the judge over and say, no, I don't need to go away and amend my particulars of claim. Yeah, that's preparation. You may well, and commonly these sorts of situations, particularly strikeout applications, need legal advice, frankly, because it can get a little bit technical as to what is a compliant particulars of claim and what is a non-compliant particulars of claim. It doesn't seem fair, does it, that a litigant in person can get struck out and be on the wrong end of a $2,500 cost bill when they've done their best. What's happened to access to justice? Here's my particulars of claim. Can't the judge just sort of talk through it and tell me to make some changes and then we're all hunky-dory? Unfortunately not. The law and procedure says that if you're going to come to the court to sue someone for money, you've got to come through a gateway and you've got to have correctly pleaded a cause of action. And in complex cases, like a police prosecution, action against the police, or financial mis-selling, or complex property case. You have got to have first decided what the correct cause of action is. So, so that's number one, preparation. Then when you get to the hearing, obviously, that hearing will be focused on you convincing the court why it is that your particulars have been correctly drafted. It's not about you saying to the judge, I've got a rock solid case and here's all the evidence and I've brought my suitcase of all the documents. The judge has only got 20 minutes to read the papers before the hearing. You've got to focus on why it is that you have correctly laid out your particulars of claim. And that means identifying the correct causes of action and particularising losses. People often send off a claim form and they put before they're up in the air in the middle of a dogfight, they think, well, I'll put in 10,000, that's about right. And they knock off a claim form and then they discover that they're wrong end of a strikeout application because the opponents say you haven't correctly particularised your losses. So you could even be on the wrong end of a cost order just for not properly laying out precisely what financial remedy it is that you are seeking. So that would be a case. Another classic case, and I had this with a possession case we had recently, who came to us quite late in the day, and there was a couple of hearings in which the lender had made an application because of failure, because the client was in arrears, and he had a big defence. He was a true blue, and he really did think that the lender were in the wrong, and he wrote long, voluminous letters and even complicated civil procedure rule Part 18 requests for information, subject access requests, huge defence document, a whole witness statement, everything like that. But the thing is, at the hearing, so he was swamped with a whole load of potential issues to do with his case, but in fact, all the judge was concerned with, and the judge has got a morning set aside where they look at 12, possession applications, and all the judge is concerned with, has the lender proved that they own the mortgage that's over the property? Has the lender got, the title deeds proving that they've got a charge on that property? If the mortgage company has transferred the mortgage from one company and it's gone on to another, that there's a notice of transfer, assignment of the mortgage. Interestingly also in this particular case, the judge was concerned that the lender hadn't correctly particularised the amount, of the arrears. So that was all the judge was interested in. You've only got, a limited amount of time, and if you start soapboxing about something else, you need to have sat back and seen that actually the issue is judges have complex kind of defences every day of the week. They're going to give that lender a possession order, providing that they've, as I say, proved these basic few things. Also, the client didn't realise that his defence wasn't really going to work, and he hadn't let go emotionally of the defence, which meant that he wasn't focused on, when it went against him, of making submissions to the judge about the issue of how much could he pay now, how much breathing space could he have, could he vacate the hearing and adjourn it to give him time to access funds to pay off the arrears. That was a far more kind of pressing issue than how scandalously, fraudulently, corrupt the lender was, and how the lender hadn't answered all his requests for information, disclosure of documents, and hadn't, in his mind, complied with the civil procedure rules. As I say, don't get tangled up in the law. At the end of the day, you've got a judge who's got a person who's in substantial arrears, and the question is, how's he going to pay them? Now, if you have then focused on the issue of how am I going to repay them, then you can actually stretch out proceedings. Lenders have to take into account your financial circumstances. You can say, look, I want a 2-year repayment plan of £50 a month, and you can then start to negotiate, and that's the issue that you need to close with at the hearing. Another issue that's crops up in interim hearings, very common, is where you've completed the directions questionnaire. It might be listed by the court, or the parties might ask for a hearing in the directions questionnaire to deal with the issue of allocation. So quite a critical issue, because if a case is allocated to a small claims track, the other side doesn't get its legal costs paid even if it wins. Yeah. Now that might be very critical to a litigant person, because he doesn't want to be at the wrong end of, if it's allocated to a higher track, at the wrong end of a cost audit. He may be afraid of going forward with his claim or defending a claim, of having to pay the other side's legal bill if he loses. So the issue of allocation can be really critical. So when you turn up for this hearing, and even if it hasn't been listed for allocation, it's clear that there's an allocation issue, you want to be focusing on that issue. For example, rather than all the other, I was about to say Penelope, but I don't mean that, do I? I mean all the other Penelope, I can't think of the word. Instead of focusing on a whole load of other things, such as, failure to comply with disclosure or respond to a letter, or their defence is rubbish, or you need a disclosure, you need to make a disclosure application for what X, Y, Z. You are focusing on allocation, and you've only got a limited amount of time, and that's probably one of the most important issues that you're going to have at this directions questionnaire hearing, and so you need to be prepped up for that issue. For example, if you are then prepped up and you've understood that is the critical issue of the interim hearing, then you can score a result. For example, you could, particularly relevant under the new fixed cost regime, you could admit part of a claimant's claim to take the value under 10,000 into the small claims track range. Or you could do the reverse. You could say, I'm going to need 3 witnesses, and therefore it's going to be a day trial, and the small claim is only a half-day trial. So it can't go into the small claim, it's got to go up to the fast track. So allocation is another area where there are problems. One more example would be where you've been unable to properly prepare your defence because there's some vital disclosure, or your particulars of claim because there's some vital disclosure missing from your opponent. It might be something simple like a contract or the invoices or whatever it might be. You arrive at an interim hearing. You may make a specific, if you don't get an opportunity in an interim hearing, you may make a specific application on an N244, so you add an extra interim hearing to the litigation cycle, in which you apply, which you ask the court for particular documents. It's like focusing on these key issues of these interim hearings that often have very little to do with the substance of your claim and far more to do with the conduct, the management of the case, and scoring little victories. Because, and I come on to, just one more example would be an application to set aside judgment. Quite common, where, like let's say a big corporation forgets to file a defence in time. Claimants often get very excited against in person. They think that they've won because they've got judgment in default. Sorry, your opponent will just make an application for relief from sanction, will have a hearing, will win, in all likelihood, I'm afraid, and and if you have not focused on the issue of whether they've got a good reason why they filed their defence late, let's say, if their application for relief from sanction shows that it was just some event outside their power, or it was relatively minor, or they acted promptly to get one in, they only missed the deadline by a few days. If you oppose their application and it goes to a hearing, you could be on the wrong end of a costs order, even though, because you should have agreed, you should have seen that their transgression wasn't particularly serious, and agreed to their application for relief from sanction before spending the money on a hearing. I hope that helps, sort of, those examples give you an idea of issues. Why is all this so important? It's because, well, I think it's self-evident, but it's also especially important because civil litigation is all about costs. And, if you've made that disclosure application, you've asked for an interim hearing on an N244, you need to focus on the issue that is always in the background of any other issue and should always be addressed by lawyers, especially at the end of interim hearings, is, look, Your Honour, we want summary assessment of our costs of being here today and the preparation for today's hearing. That could be a significant sum of money. Litigants in person can claim their costs. I refer you to a very good book on the topic. Right at the end, page 295 actually, you can actually claim costs as a litigant in person. In fact, the legal authority is that if you're in a high-flying, high-paying job, you could perhaps claim quite a high amount of costs. I think it's capped at 2/3 of what a lawyer would get, which can still be obviously quite a significant amount. Just while I'm on plug mode, there's sections on interim hearings. All of what I'm covering is in there, and examples of how to handle it, and how to draft various necessary documents, read court orders, and so on and so forth. Right, yeah, so costs runs throughout. There's a section of costs in here too. Drafting up a statement of costs, the CPR says that you should get a statement in costs before the hearing, signed and dated, to get the judge to give you permission. Now, if you're too busy on other issues and you completely forget about your costs, and you haven't got a piece of paper, there is a court costs form, incidentally. I think it's an N260, if memory serves, for interim cost summary assessment. Or you can do it yourself, just make it nice and clear on one page, in which you're claiming your costs. You also need to focus on the issue of costs, because the other side may come with a big list of quite a significant amount of costs, and you need to be ready to attack their costs and say, no way can you all award them costs of £5,000 for today's 30-minute hearing, and get so costs are always there in the background. As regards court wingman, because you'll often have incurred court wingman costs, what we're finding is that basically they should be awarded too. But at the moment, the courts aren't completely up to speed. We had one hearing where the judge had no problem in giving him his court wingman costs. We had one hearing in which the judge decided not to give him his court wingman costs. Now, it may be not because it was court wingman background advice rather than as just a conduct of litigation. It may not be just that judges aren't used to these type of support services. It may be actually that the judge wasn't inclined to give the client more costs than, wanted to cap the amount of costs that was going to award, which is often, which is what judges specialise in doing, hacking down your costs. Now here's the other thing. Interim hearings, it's actually, when you think about it, about getting prepared for the hearing. Yeah, so let's just talk a little bit about the importance of preparation. For example, you may decide to agree with your opponent to vacate the hearing. Now, if you're going to do that, you'll need a consent order. If you're a litigant in person against someone who's represented, get their lawyers to do it, but you ask them to send a draft consent order to you so that you can look over it. We've got examples of consent orders, an example of a consent order in here, by the way, in the book. So that's often, in the possession case I referred to above, that was a critical part of preparation for the hearing, and enabling us to get a hearing vacated and knocked into the long grass, which saved our client from getting his house possessed. The other thing that you might want to include in advance of one of these interim hearings is a draft order. Again, can be quite a powerful thing. It's a kind of consent order, draft order, you know, in a way they're the same type of document in the usual form with the tram lines, you know, and on one little page it might say the judge, unless the opponent discloses the invoices upon which his claim is based within 14 days, his claim will automatically be struck out. If you draft that into a draft order, you're thinking ahead, you're preparing for the interim hearing, you're preparing to address the issues that are going to, you're laser focused on the issue here, and you send that to the court in advance, at least 2 days, but preferably give the courts more time than that. But you will often, if you are down to the wire, make sure you're marking your emails urgent for hearing tomorrow at 10 a.m. And then the judge has got a draft order, and it gets him thinking along the right lines, because a lot of the problems is you're not getting, this isn't an idealistic ivory tower world. This is busy judges haven't got time to read papers, with papers that go missing, with online hearings that just evaporate because of a technical problem, of lateness, of earliness, of one party being there, one not. Yeah, it's a dogfight. So you want to maximise your chances of winning by being properly prepared and, for instance, getting a draft order and your statement of costs in with the court beforehand. Court orders. People often, and lawyers often forget to read the small print, the details in the court order. If you are doing what a court order tells you to, for example, an electronic bundle to be lodged at court 3 days before the hearing, or the expert to the claimant to provide their questions that they want the expert to answer, let's say it's respect of a building dispute by such and such a date, people often forget to read, it's amazing, isn't it really, but we often get to read the small print of court orders. So an interim hearing usually nearly always arises as a result of a court order. Now, I'll just talk briefly about bundles. You probably are aware that you have to prepare a trial bundle. Yeah, but what about interim hearings? Well, the same kind of general rule applies. It's not, in my view, it's not essential. Let's say you've made an application and it's only 12 pages. Let's say it's a witness statement and you put some exhibits alongside a witness statement. It would be unnecessarily complicated to create a trial bundle as well. Just use your noodle about what's needed. If there are lots of documents, if it's likely to be lots of documents spread out all over the place that the judge might not have ready to hand in his court file, create a bundle. Yeah, and sometimes the court will order a party to file and serve a bundle. And that means you put everything that you're going to need to argue the particular point that's being argued at the interim hearing, not the whole bloody case papers, but just what is needed for the interim hearing. And then once you've got that in all apple pie order, you then number it. You can do it on a PDF, but you can also just handwrite 1, 2, 3, bottom right hand corner in a black marker. Yeah, and then you put it through the PDF machine and you send it to the court, or you post it. Be careful about the size of the megabyte limit for the particular court that you are working with. Now, I talked about an epiphany earlier on, and that is transcripts. In this possession case that I was telling you about, the client had the savvy to get a transcript of the hearing. All hearings are recorded, folks. yeah, in public ones, and it should be public unless there's a good reason for it not to be. You can apply to a service, and you can actually Google it. I'll try and find the form and put it up on the screen. With the services that you pay some money to, I think it's a price per page, who will then, and I think if you pay more, you get it more quickly, who will then provide you a transcript of the hearing. Why is this so valuable? Because it will help you, if you read it, to get a really clear understanding of what the judge and the court is thinking about your case, and read between the lines. And if you're going to get a lawyer involved, or if you're going to get court wingman involved, oh my God, it is so helpful, and it will save you money because we won't have to read through all the case papers. If we've got a case summary, the judge and the two parties will have closed with the issues at hand. Been absolutely golden in being able to provide good service to the client, and it also means we know what's going on. We've got the feel of what's of how the court is treating this particular case. So I do highly urge you to get hold of transcripts. They can be very helpful. Okay, yeah. So I just said at the beginning I would list a sort of what sort of interim hearings you might be faced with. A lot of them I've already mentioned. Applications to set aside a default judgment, summary judgment, strike an application, applications for relief from sanction, applications for disclosure, applications for expert witnesses. The courts can list hearings for any reason. I've had cases where the court just bats an issue because it hasn't closed with it, or there's missing documentation. It says come back in a month, and then relists it for another half an hour hearing in a month's time. The court can also, of its own volition, of course, list hearings. Directions hearings, critical, and of course in multi-track cases, case and costs management conferences, where these lovely old precedent H's get rolled out. Now, in relation to the law, as you can see, a lot of what I've said has very little to do with whether there's been a breach of contract or there's been negligence and so on and so forth. You will have had to have completed that correctly in your particulars of claim. But when it comes to these interim hearings, they're often about these management issues. So please stay focused on managing the conduct of the case and not in trying to have a mini trial before the actual trial. It's quite a lot of self-discipline required, because you want to just, beat the drum and have a go and say how dastardly your opponent has been and how the court would be mad not to side with you. So just one final thing, just to illustrate and ram home this point. You'll often find at these interim hearings, particularly where an application is being made on an N244, and I see this a lot. Again, it's the wood for the trees problem. Just to give you an example of a common kind of error. Let's say you're at a preliminary, at an interim hearing, and let's say the issue is your opponent's failure to disclose some invoices, yeah? If you've understood that that's going to be the issue, the main issue for you at the interim hearing, you need to have produced a witness statement, a short witness statement, exhibiting the letters in which you've asked for that bit of disclosure, yeah? A chaser email, perhaps that you've even specifically asked for it in a piece of pre-action correspondence that could have settled the whole case if that invoices had been supplied at that earlier stage. So when you've closed on the issues and you decide that the issue is one of disclosure of these invoices at the interim hearing, you can then provide a witness statement which exhibits the fact that you've tried to get hold of the disclosure and failed. Do you get my point? This is where CPR Part 18 requests often come in, specific questions or specific documents that you've require your opponent to give you, without which it's impossible to prepare your statement of case, let's say. You need to submit evidence to the judge so that he's not inside your head. He's had 15 minutes to look at the papers. He needs to see a nice, clear, concise witness statement with that letter attached, in which you lay out, I'm going to be making an application for disclosure unless within 14 days you provide me with these invoices. So do you see how it's a bit like chess? As you're approaching the interim hearing, you need to be thinking ahead to what it is that you need to be doing, and therefore you need to know what issue it is that's going to be addressed, and then what evidence off the back of that issue you need to supply, and therefore you need to, in this instance, put your opponent on notice that unless they supply the disclosure in a letter that you can then exhibit to a witness statement. So hopefully that makes sense. I've plugged a lot today, but I hope you'll forgive me. It's just, well, I've plugged the book anyway, but with Court Wingman, I think we can add a lot of value. Often it's rather painful, but better take the pain, a little pain early than a lot of pain later. When it comes to dealing with interim hearings. So don't hesitate to give us a call. Send us your documents in apple pie order so we can skim through them and quote you low, and then we can make sure that you go into the dogfight with a really good navigator behind you. Okay, that's all for now, folks. As I say, the next vlog up will be diving deep into the issue of issues.